Hey there, Jim Hart here from the Hart Law Firm, and I thought I would do a quick video today outside because it's a beautiful day here in North Carolina. It's in the 60s, mid 60s degrees outside. It's beautiful, and today I want to talk to you about why beneficiary designations are not an estate plan. And I get this from clients all the time. I'll be honest, it pisses me off a little bit. In fact, I had a client it was supposed to come in a week or two ago, and they called me, or I typically, what I do is, my process is, I'll send you out, if you want to come in and meet with me, I'll send you out a bunch of information, and then I ask my clients to return that information to me before they come in, so I can kind of customize the plan that I'm going to do for them, and kind of understand what their situation is and customize the presentation. Sorry, I'm getting text messages here. I got to turn those off. Anyway, so I like to know a little bit about the prospect before they come in and meet with me. Now, typically what I'll do is, after I mail that out, I will follow up with them, about a week before the meeting, if I haven't received the documents back, to see, did they receive it, do they have any questions, anything I can help them with to fill it out, and so I did that with a potential client, and basically they said, we've gone through this is really more than we need, and we've already got a lot of our beneficiary designations in place, so we really don't need this. Now, there's a lot of reasons why people decide not to hire an estate planning attorney or not to move forward with the process. It could be they're scared of the process, it could be they don't want to deal with the cost of the process, it could be that they're just overwhelmed by what it's going to take to finalize an estate plan. And those are all legitimate reasons to maybe not move forward. Now, they're not good reasons to not move forward, because everybody needs an estate plan. But those are good reasons. But when somebody tells me, we've got our beneficiary designations in place, so we do not need an estate plan because we've already got it taken care of, that to me says they don't really understand what an estate plan does. And so I thought I would take a minute today to explain why just having beneficiary designations in place is not an estate plan, and that's not a good alternative to doing your estate plan. And there's a lot of reasons. Number one, probably one of the biggest reasons is, one of the things we do with estate planning is we don't just plan for what happens if somebody dies. Everyone thinks, well, this is what happens when somebody dies, so my money's going to transfer, it's going to be out of probate, no issue there, we don't need to worry about it. But that is only part of the equation. The other part of the equation, which is far more frequent, is what happens if somebody becomes incapacitated. Beneficiary designations will do nothing in that situation. If somebody becomes incapacitated, that money that's in their accounts, whether it be retirement accounts or investment accounts or their bank account, it's going to be basically locked up if you don't have an estate plan in place to deal with that, or you've named somebody to manage those those funds for you. That money is going to be locked up, and you're not going to be able to do anything with that. So that's the first big problem of beneficiary designations, is they don't do anything when it comes to times of incapacity. Another reason why beneficiary designations are no good is because a lot of people leave their money through the beneficiary designations to either their spouse, which is fine, but then they also leave their children as contingent beneficiaries. And if their children are minor children, this is a problem, because basically they're setting up a huge expensive court process for their children to deal with that money if they inherit it. And then, assuming there's money left over when the child turns 18, if there's anything left over, that money is turned over free and clear to the child to do with as they want, with no restrictions, no oversight, nothing at all. The child just gets that money then, and that's it. And who knows what they're going to do with it? I can tell you right now, when I was in high school or college, if somebody handed me $1 million, it would have changed a lot about what I would have done and the choices I would have made, and maybe not always for the better. So that is another major consideration, is that people leave money to their minor children through beneficiary designations, and that's a no-go. That's no good. Let's see. So what have we touched on? Incapacity planning, beneficiary or minor children. Taxes can be an issue. It's not a huge issue because for most people, estate taxes are not a huge issue. So that's not a main concern. But I would say those two are the big two. And shoot, I'm blanking. There was a third that I want to talk about today. I may think about it here in just a second, but those are the main two. So it's not going to do anything when it comes to incapacity planning. And I guess that would be the other thing. If you have children, and even if they're not minor children, you're going to leave money to them through incapacity plan or through your beneficiary designation. The big problem there is there is no oversight over that. That you're not protecting that money in any way, shape, or form. So if you're leaving it to a minor children, it's going straight to the minor children, no oversight there, no asset protection there. If they've got creditors or if they need to declare bankruptcy or anything like that, excuse me, no protection, no creditor or protection from anything like that, bankruptcy, divorce, etc. That money is there to them and it could be lost. The second main concern is when it comes to blended families. So if you leave that money outright to your spouse, you're not providing any type of protection if your spouse gets remarried and then something happens to them. The money could go to their new spouse or potentially stepchildren with your children getting completely cut out, and we've seen cases where that happens quite frequently. So those are the big three things I would say are: it doesn't protect in the event of incapacity, it doesn't protect if you leave the money to your minor children, and then finally it offers absolutely no protection from creditors, from bankruptcy, from divorce, from lawsuits, from anything like that. And then kind of the bonus is there, it doesn't protect in the event of a blended family situation. So, you know, this is one of the reasons why I like to bring people in and meet with me and talk about this, because they don't understand that these are all potential problems when you're just using beneficiary designations. They are a wonderful tool to avoid probate and things like that, but that is not typically the biggest issue that a lot of my clients face. A lot of my clients face a lot of other issues besides just probate avoidance. And probate avoidance is easy to do with estate planning as well. Probably a good benefit to estate planning, but it's not the only benefit. There's all these other things that people forget about. And so I think I'm going to leave you with that today. I'm using this, you can't see it, but this tripod thingy to hold onto the phone, and it's actually quite heavy, and when you got your arm out, you know, like this, it gets heavy. So I don't know how long I've been talking, but that's kind of it for today. Beneficiary designations do not equal an estate plan. That's the biggest thing I want you to take away from this. And if you have any questions, feel free to give me a call at 919-460-5422. We'd be happy to help you anyway. If you're in Wake County or Cary, North Carolina, that's where our office is located. And have a great day, and I will come back with another video here later this week. Take care, folks. Bye-bye.